Is your theft charge a felony or a misdemeanor? Imagine walking out of a store with a few items you didn't pay for. Now, what happens next depends on a lot of details. Your theft charge could be a misdemeanor or a felony. It all comes down to the value of what was stolen and other circumstances. Theft means taking someone else's property without permission and with the intent to keep it permanently. If the property is worth a small amount, usually under $500, it's often a misdemeanor. That means fines, probation, or up to 1 year in jail. But if the property is worth more than that, the charge can become a felony. For example, in some states like Alabama, stealing property worth over $2,500 is a higher degree felony. If you steal a firearm or commit theft repeatedly, it can also turn into a felony. Other factors that can make theft a felony include using force or violence during the theft, breaking into a building to steal, or stealing from certain protected groups like employers. Even possessing stolen goods worth a large amount can lead to a felony charge. The law varies from state to state, but generally, if the value exceeds a specific dollar amount, the theft is considered a felony. For instance, in North Carolina, stealing property worth more than $1,000 is a Class H felony. If the theft involves a firearm, explosive device, or is a repeated offense, it can be a felony no matter the value. From a defense point of view, it's important to look at how much was stolen and the circumstances. Sometimes, the value can be disputed, or the intent can be challenged. Long-term consequences of a felony include losing voting rights, difficulty finding work, and restrictions on housing. So, if your theft involves property worth more than the legal threshold or has aggravating factors, it's likely a felony. If not, it's probably a misdemeanor. Always check the specific laws in your state and talk to a lawyer to understand your options.